All right. Okay, let's go on the record on, give me 1 second. We're going on the record on cause number. Oh, shoot. Do you have the cause number, Mr. Shelton?
Yes, it's DC 19-12033.
And that's Stevens versus Reyes. Is that correct?
Yes, Your Honor.
All right. We're here on a pretrial for a trial that's going to start tomorrow. I understand you guys have had an opportunity to conference. First off, let's deal with the motions in limine. Any objections to the plaintiff's motion in limine?
No, Your Honor, no objection.
Right. And I don't understand defendants don't have a motion in limine. Is that correct?
That's correct, Your Honor.
That is correct, Your Honor. I was going to make an oral motion for a leave to file the motion in limine.
Mr. Shelton?
Yeah, unfortunately, I told Ms. Campbell I'm easygoing, but here, the day before trial, I'm going to have to object to that.
So why don't we just have an oral motion that your client won't discuss insurance? How about that?
That's perfect. Thank you.
So, Mr. Shelton, is
That's
that
fine.
clear?
Yeah, absolutely.
All right. So with that exception, you can we'll deal with the motions. Do we have exhibits we're going to pre-admit?
Yes, Your Honor.
All right. What exhibits the plaintiffs have?
Plaintiffs we have an agreement on plaintiffs exhibits 1 through 11.
Is that correct, Ms. Campbell?
Yes, that's correct, Your Honor.
And those are affidavits for records and billing, as well as some photographs of the plaintiff and defendant's vehicle. We have filed an amended exhibit list, adding exhibit 12, which is a dash cam video my client took driving the route of the wreck. We did not exchange this in discovery. I don't know why. There was a request for that. So I'm not attempting to introduce it as an exhibit, but more of want to use it as a demonstrative aid. And I've told Ms. Campbell, she narrates while she's driving this. I don't plan to use her narration. I just plan to show the video that is consistent with her deposition testimony about how she drives this route, because it's a lane dispute, whether she was in a turning lane and defendant was in the lane to the right, which is a straight only lane, and then turned, or whether my lady was in the turn only lane and defendant was in the turn straight lane and my lady went straight. That's the essence of the dispute. So 12 is just a demonstrative to show her testimony about how she drove the route.
Ms. Campbell, do you have an agreement on that?
No, Your Honor, we were objecting to number 12. That video was outside the scope of the discovery. We were just noticed of that on April the 6th.
Why don't we discuss that tomorrow and we can deal with that.
I'll show it to you, Your Honor, and you can make a decision there. I want to know, because I plan to use it in opening, if you're going to allow me to use it as a demonstrative.
What about defendants? Do they have any exhibits?
Let me look, Your Honor.
No, there was not an exhibit list filed for defendants.
I don't see an exhibit list. I would just refer to whatever documents Mr. Shelton has on his exhibit list.
And then I understand there's some line and page designations questions, or what's the issue with that?
I have no objection to those. I was just confused as to why they were filed, because I'm being told that the defendant, normally with Fred Loya, if they file page and line designations, it means they don't have a client that's going to be there. But they're telling me she's going to be there. I don't have any objections to what they filed. We discussed, Ms. Campbell and I discussed, if for some reason she is not there, we're going to go through her depot, remove any references to insurance, and just have the whole thing read at one fell swoop instead of cross designations. I think it makes it smoother.
No objection.
Okay, great. So let's talk tomorrow. So it sounds like this is a contested liability case. Is that right?
Yes, right.
Okay. And then the contested liability is, so we're going to have plaintiff and defendant both on the charge. Is that correct?
Correct.
I anticipate, yes.
And then what are the elements of damage you're seeking, Mr. Shelton?
Past medical expense for my client, and then she had both of her children in the car. They both went to one doctor visit. So we have those so past medical for my client and her 2 children, past pain and suffering and mental anguish, and past impairment for mom. No other damage elements for kids.
Okay, so for mom, it's past medical, past pain and suffering, past mental anguish, past physical impairment. For kids, it's just past medical, is that right?
Correct. PD's already been paid, so, and there's no wage component.
Okay, perfect. All right, I'll put together the charge tomorrow. Just make sure we get started at 9 in the morning, and so just make sure you're there. And we're gonna. And I don't know, Miss Campbell, if Mr. Shelton told you, I know there was Mr. Woods, I think, on this as well.
Yes, sir.
We had talked about delaying this trial to Wednesday, but both Mr. Shelton, Mr. Woods had said that they would prefer to just go tomorrow, that we're going to have kind of a long lunch break. And so because I have a CLE that I'm helping to teach with the new judges. And so we're going to just be aware that there's going to be kind of a long lunch break. And normally I don't like doing that, but it's just, this was scheduled a long time ago.
Sure.
All right. Anything else, guys?
Nothing, Your Honor.
Nothing further from defense, Your Honor.
We'll see you tomorrow.
See
See you in the morning. Thank you.
Judge.
Okay, so our next hearing is first off, is anyone else here on the dismissal docket? He's not working. What's the okay? There it is. Anyone here on Saud versus Ibrahim?
Yes, Your Honor. Cal Hamida for the plaintiff.
And Trustee McKinn for the defendant, Quilisi Holdings Company.
All right, let's go on the record on DC 224220, Saud versus Ibrahim. Counsel, make your appearances.
Cal Hamida for the plaintiff, Your Honor.
Trustee McKinn for Quilisi Holdings Company.
All right, you may proceed.
Your Honor, I think we do have an agreement that I will not oppose the granting of this motion. The defendants will reimburse my firm attorney's fees in the amount of $2,250, and we'll give you back the rest of your time.
My client has agreed to that if the court is amenable, Your Honor.
All right, give me a little, this is a motion for new trial, is that right?
Yes, Your
Yes.
Honor. I can give you a quick spin.
Yeah.
Okay, so basically, Quilisi Holdings Company, they did file an answer. It was filed by the president of the corporation, and it was timely filed back in May of 2022. But thereafter, the plaintiff moved for a default judgment.
Oh, I recall this. I recall
Yeah,
this.
post the answer. And then to make a long story short, the client wasn't served with the notice of the hearing of the default judgment, never got any notice of anything. The default judgment that was entered by the court was mailed out pursuant to the rules, but it was mailed to the wrong address. I mean, the address, it wasn't the correct one in the cert of service that had been filed by the plaintiff or the one that was on the answer filed by Quilisi Holdings. So Quilisi Holdings didn't find out till basically late January that a default had even been entered. That's the nutshell version, Your Honor. I can give you more details.
No, I remember it now. Let's go ahead and give me an order on this, Mr. Hamida. Make sure that it says this hearing was heard at the beginning instead of on this date. Have it say this was heard on April 10th, 2023, and indicate that it's an agreed order.
Will do, Your Honor.
And Ms. McKenna, I don't know if you know this, but there's a trial setting on this case for October 24th.
I did see that this morning, Your Honor, when I checked the court's docket, but thank you for telling me that.
Okay. All right. You guys have a great rest of your day. I'm glad you guys worked this all out.
Thank you, Your Honor.
Thank you. You guys are excused.
Thank you.
Mr. Wiley, I guess is it. Mr. Wiley, what are you here for? Oops.
Good morning, Your Honor. I think I'm early. I have a case status conference. I think it's at 10 a.m. I just found out.
Let me see real quick.
It's for the Rodriguez case. I can give you the cause number.
Rodriguez, it's a scheduling conference. isn't
Yeah,
it?
it's scheduling conference. Yeah. So is that at 10 a.m.?
Yeah, and there, we just need a scheduling order. Have you guys not submitted one yet?
I don't think we have. I just found out about this, I guess, on Friday. So
Okay.
if that's all we need to do, I can just get with the defense.
No, we'll need to meet with them just because
Okay.
we need to get a trial setting and everything. So, all right. So we'll, as soon as they get here, we will take care of this matter. Okay.
Okay, sounds good, Your Honor.
All right. I think both sides are here now. Mr. Wiley, Mr. Gonzalez. Mr. Wiley, Mr. Gonzalez, are you there?
Yes, Your Honor. I'm trying to. There we go. Sorry about that, Your Honor.
That's okay.
I th-
So I think we just need to get a scheduling order in on this case. So when, all we really care about is when you guys want to set this for trial and who you want your mediator to be. So, and if there's any other issues you need me to resolve.
Mr. Wiley, you told me I don't think so. I think we're fine otherwise.
Yeah, same here. I don't know of any issues. And I'm fine. I'm sure I'll be fine with whoever Mr. Gonzalez suggests as a mediator.
Well, let's pick first off, let's pick a date for trial.
Okay.
How much do you guys still need to get done on this before we? When are you approximately thinking of? And I'll look at dates.
Mr. Wiley, what do you think? I know you're based out of Houston, so you
Yeah,
tell me.
I am. I'd say toward the end of the year or early next year. I mean, think you've just filed an answer, so it's not a very complicated case.
Agree.
You want January 2nd, January 9th?
Probably the
January
9th. I would
16th.
prefer, yeah, the 9th should work, or even mid-January.
January 9th is fine, Your Honor.
Okay. All right, we'll go ahead and set it for trial on January 9th, Rhonda. Okay, and then let's pick a mediator. Who do you want to use?
Mr. Wiley, again, I always like to defer to y'all. I mean, on our side, there's just Your Honor, if you have any preferences, I know there's been all sorts of changes about the rules about mediators and how they're assigned or picked, but the ones that I always find
This
successful.
isn't on a wheel because this is a level 3 case, so
Okay.
we don't have to put it on a wheel. So you guys get to choose it essentially, but who do
Mike
you-
McCullough, from his group, Jim Hitzelberger, Martin Terry.
You're in Dallas, Mr. Gonzalez?
Yes,
Okay.
I am in
Yeah,
Dallas.
I'm out of Houston, so I've used mediators in Dallas, but I usually use a lot more in Houston, so.
Yeah, but if this is a small car wreck
Yeah.
case, then McCullough and Terry Hitzelberger, Ken Rubenstein is good, though he tends to handle somewhat bigger cases.
Yeah, I like Ken. I've used Rubenstein before. I like him.
Okay, I'm fine with Ken,
Okay.
Mr. Rubenstein.
All right, let's go ahead and appoint Ken Rubenstein on this one, and then you guys, we're going to go ahead and set this for trial on January 9th. We'll appoint Mr. Rubenstein as the mediator, and then you guys put together whatever scheduling order you want, and if there's anything you feel like you need a ruling on, I can make that now, but if you feel like you can put it together, then I'm okay with that too.
I think Mr. Wiley, tell me if you have any other thoughts, but I think we're good, Your Honor.
Yeah.
And and Mr. Wiley or the court, Your Honor, I have a form, a template, I think that's been used before in your court in
Sure.
particular, and it's very standard, Mr. Wiley.
Yeah, just shoot it over to me.
And since I got to everybody here, you, Mr. Wiley, I don't think we need any changes. I know it's level 3, but do you want to just go by the rules for, counter affidavit deadlines, expert designation? Again, it's not as complicated case, but I just want to make sure, since I got you here, if there's anything you want to do different.
No, I think we just go by the rules, and if you want to send me the, proposed DCO, we can agree DCO. I'm sure we'll agree to it.
Absolutely. Okay.
Okay, sounds good. Let's just get that into me as soon as possible and label it as an agreed scheduling order, and we will get this taken care of for you.
Thank you, Your Honor. May we be excused?
You may be excused. Have a great rest of your day.
You too.